Good afternoon, everybody. I'm Carolyn Laguerre Brown, and I currently serve as the Vice Provost for Diversity, Equity, and Community Engagement at GW. I am a labor and employment lawyer by trade. I started my career working in New York City as a prosecutor in the county where I was raised in Brooklyn, New York, and then later went on to the Fire Department of New York City, the Transit Authority of New York City, and worked in their general counsel's office and equal opportunity office, really working on investigating discrimination and harassment issues in the workplace and working on policy development and training. I joined the higher ed community in 2005 when my family moved to this part of the country, and I have been in higher ed ever since. I was at Johns Hopkins for 11 years before coming to GW, and I've been here for the last 6 years. I have the privilege of leading, a wonderful office filled with professionals that really care about a lot of the issues that we're going to talk about today. So I'm certainly here. My colleagues are here to do formal things like sessions like today, but we're also here to serve as an informal resource for you. If you've got an issue that's brewing and you're not sure what it is, you don't have to wait for something to be, at a fairly serious level for you to reach out and get support and get help and, navigating the different systems at the university. I want to spend just a few minutes here just talking to you about the offices that are under the umbrella of the Office for Diversity, Equity, and Community Engagement. The offices include the Honey W. Nashman Center for Civic Engagement and Public Service. That's the Center for Academic Service Learning and Community Engagement work at GW. So we always welcome having faculty who are interested in community engagement work, particularly in the DC area, to reach out and talk with our executive director there about opportunities to do community engagement work as part of your scholarship. Our Disability Support Services Office is the central office at the university for handling complaints, or not complaints, for handling requests for accommodation for individuals with disabilities. So anytime there is some kind of medical issue that presents some sort of challenge in the academic space, DSS would be the office and the resource that would handle requests for accommodation. Really important for faculty to be aware that, what you want to avoid is ever having an arm's length transaction with a student directly about their medical information or about a request for a disability accommodation. There is an office that is dedicated to working on these issues, and we're processing as I sit here, talking to you. We have over 3,800 students registered for disability support services. That's an over 70–80% increase from the time I joined the GW community back in 2016. So the office is ready to support whatever need you have in that space. We also have a Multicultural Student Services Center, which is a home away from home for our underrepresented communities at GW. It's at 2127 G Street. We also have a Title IX office that handles all sexual misconduct complaints involving faculty, staff, and students across the university. So we'll be talking a lot about the work of that office as we go through the presentation, but that's one of the offices that we oversee. My office also oversees the university's bias incident reporting response website, and that is a mechanism that exists to provide support for students. So we sometimes receive reports about faculty and staff, but we would refer those to the appropriate offices for dealing with faculty and staff issues. But the bias incident reporting site is really meant for anybody in the community who wants to report a bias-related incident involving a student, and you would use that site to do that, and I'll talk a little bit more about that. But taken together, these are all the offices that are part of the Office for Diversity, Equity, and Community Engagement. So as I start talking to you a little bit about the policies and procedures around equal opportunity, discrimination, harassment, and bias, I thought it was important for us to just begin really quickly with a legal framework that informs all of the policies that I'm going to talk about in just a second here. So we certainly have federal laws that form the basis of a lot of the policies and rules, practices that we have at the institution. We also have federal regulations that add more detail and more color to the broad federal laws that appear in this area. We also have laws that impact us that are connected to the jurisdictions that we're in, to DC and to state laws, the ones that refer to Virginia, right? Those are laws that influence what you see in our policies. We also have a lot of case law that gets developed after big broad laws get passed, actual fact patterns being presented to judges that say more to institutions, to employers about what we're expected to do when certain circumstances arise. And then finally, we have Department of Education guidance that also informs, the policies that I'll talk about in just a second. So here I wanted to just take a minute to show you just a quick look at the federal laws that form the basis of our policy. Our policies on equal opportunity and anti-discrimination. So the oldest policy that we have is the Equal Pay Act, and it gets passed in 1963, and it essentially says men and women can't be paid differently for the same job. As recently as 2009, during the Obama administration, we saw the Lilly Ledbetter Act get passed, and that essentially extended the statute of limitations for pay equity claims. So it means that every single time a paycheck gets issued, there's a new potential cause of action and a new, potential right that someone has to bring an action around pay discrimination. And it was the result of the statute of limitations preventing a person who learned years into an employment situation that they were being paid unfairly, and by the time they learned, they no longer had standing to sue for those for the pay discrimination. And so the Lilly Ledbetter Act again created the circumstance where you had a new cause of action potentially with each paycheck. 1964, we get what I would consider to be the watershed, piece of legislation that becomes the precursor for almost everything else that we see. It's Title VII of the Civil Rights Act of 1964, and it prohibits discrimination based on race, color, religion, sex, and national origin. When you look at our policy at GW, at other policies for other organizations, you'll see a much longer list of protected class categories, but that first watershed law covered these 5 categories. 1967, you get the Age Discrimination in Employment Act, and it protects individuals in the work environment against discrimination if they're age 40 or older. You will find that in state and local jurisdictions, they will take that age all the way down to 18, and it protects and guards against discrimination against both younger workers and older workers, but that federal law only covers 40 and up. 1972, we get Title IX of the Education Amendments Act. And this is the rule that forms the basis of a lot of the sexual misconduct policies that we see in the higher education setting, and we'll spend a good deal of time talking about that. And it broadly prohibits discrimination based on sex, including sexual violence and sexual harassment. 1974, we get laws, you see both the executive branch and Congress acting to protect veterans against discrimination in the American work environment. So as the government is engaging in military operations in different places and they have people coming back into the American workforce, you see this attempt to protect them against discrimination that might occur. The idea here is that if somebody fails to promote someone or fails to hire them for fear that they will be deployed soon, that would be a form of discrimination that could give rise to a cause of action against the employer for doing that. In 1978, we get the Pregnancy Discrimination Act, and it essentially says that pregnancy can't be treated any differently than a non-pregnancy related medical condition. So in the workplace. So if there are rules in place for how an employee takes time off for back surgery or for cancer, the rules have to apply in the same way for pregnancy. And this gets passed in a time in our country when you saw a lot of employers across the country implementing arbitrary rules around pregnancy, requiring people to stop working after 3 months of pregnancy or 4 months of pregnancy with no relationship at all to the health and well-being of that pregnant person. And so you see this attempt to protect against that form of discrimination. Title IX also has a lot of provisions embedded within it that also requires academic institutions to make certain accommodations for pregnancy in the academic setting, and we'll talk about that a little later. And then we have in 1990 and 2008, the Americans with Disabilities Act and the ADAAA, which is the Amendments Act. And essentially this requires American employers to come to the table in good faith to determine whether or not we can provide an accommodation if a person with a disability asks for one. And so we'll spend, a little bit of time talking about that as well. And then in 2008, we get the Genetic Information Non-Discrimination Act. When this gets passed in our country at a time when technology started to advance and the ability to predict certain kinds of, propensity for developing a medical condition. The idea here is that if an employer were to use knowledge of somebody's predisposition to developing a particular illness against them in a hiring process and a promotion process and any sort of, term and condition of employment, this statute would give, that person the ability to raise a claim on that basis. I've not seen cases of this actually filed in any jurisdiction, but you can imagine as the technology advances, the danger of this, came into existence, and you saw this attempt to protect people against this form of discrimination. So like I said, it's sort of a quick look at a glance. I know I went through a lot there. Are there any questions about any of these federal statutes? I'm happy to take any questions. Okay, great. All right, and there are a couple of federal laws I already talked about, the Title IX of the Education Amendments Act that cover academia specifically. We also have Title VI of the Civil Rights Act. And this doesn't get talked about anywhere near as much as Title IX, but this is also a really important statute for faculty to be aware of in our interactions with students, and and just thinking about the environments that we are responsible for, for supervising. Title VI is something that we also have to guard against. So it prohibits discrimination based on race, color, or national origin in programs or activities receiving federal financial assistance, right? And so a lot of attention goes toward the Title IX, but Title VI is also something that we have to guard against. And then we have Section 504 of the Rehabilitation Act, and this protects the rights of individuals with disabilities in programs and activities that receive federal financial assistance. So this is the Section 504. It expands the ADA and really addresses specifically disability in the context of education. Okay. Any questions about these higher ed laws? Okay, great. So these are the GW policies taken together that cover broadly equal opportunity and non-discrimination at the university. I will send these slides, to the group, and all of these slides are hyperlinks. And should you want to review any of these, all of the actual policies can be accessed through this slide. The first is the equal opportunity, non-discrimination, anti-harassment, and non-retaliation policy. Say that 3 times fast. This is the broad policy that prohibits discrimination. It covers our entire campus community, faculty, staff, and students. It's broad, and it also contains a lot of information, definitions about what we mean when we use the phrase discrimination, when we talk about harassment, when we talk about retaliation. All of that is defined in this policy. There are examples of the kinds of conduct that would fall under this policy. And there is also pathways to complaining. We'll also have a slide in this slide deck that talks about your different pathways for raising concerns at the university or for fulfilling your obligation under some of our policies to report things that but this is a really good policy to just a one-stop shop for understanding where different kinds of complaints go. Then we have the Title IX sexual harassment and related conduct policy. And this is the broad policy that covers sexual misconduct. And we'll spend a little time, later talking about that. And then we have a prohibited relationships with students policy. This is a really important policy. It's relatively new at the university. It was put in place in 2018. And it broadly just, bottom line here is that faculty are prohibited from having relationships with undergraduate students. That's really a blanket, prohibition. Faculty are also not permitted to have, relationships with graduate students who they are responsible for teaching and supervising. The policy is really, it's not super long, but it does have a lot of really good information. It defines what a teacher is, so you can be really clear about that. It includes TAs, it includes graduate students that have any sort of, responsibility for other students in terms of grading or, leading a class in some way. So it really gives a lot of clear definitions about who is subject to this policy. And I can tell you that when this policy gets violated, there's usually serious employment action. So you should make yourself aware of this policy and take a look. We also have a disability policy that broadly, states the university's commitment to complying with the ADA, complying with Section 504 of the Rehabilitation Act. Disability is also covered in that first policy, in the first bullet, in the broad equal opportunity policy, but the disability policy is specific and addresses our commitment to access for individuals with disabilities. And then finally, we have a protection of minors policy, which says that everybody on this call for sure is obligated to report any sexual misconduct that they become aware of with minors. And I think the rule of thumb here, and we'll have a slide about this later, is just don't talk yourself out of reporting. If there is any doubt in your mind that you have that kind of information about a minor, you must report it. And that's a blanket obligation for everybody in the community. Any questions about these policies? Great. So quickly, I just wanted to cover in our equal opportunity policy, these are the protected class categories that are included. So every single person on this call is a member of multiple protected class categories. Often when people think about any discrimination laws, they think often that they protect only women and minorities in the workplace. And that couldn't be further from the truth. If you look at any of the broad federal laws that I talked about, they don't say women, they don't say minorities. It says don't discriminate, right? It's about the conduct. So every single person in the GW community, if the types of conduct that we will discuss today are directed at that individual, that person has the ability under our policy to raise that concern through the various reporting and complaint mechanisms that the university offers, okay? So, and this is a combination. What you see on the screen here is a combination of protections that we get from those federal, local, and DC laws that I talked about earlier. And the policy even has a catch-all. It lists all of these different categories and then says, and any other legally protected characteristic, because sometimes our local jurisdictions make changes, they add protections. And so the commitment that is, present in the policy just is to subsume any additional protections that might come from the jurisdictions in which we sit, okay? So quickly, theories of discrimination, the types of complaints that we see. And I'll go through each one of these individually. The most basic kind of complaint that we see is a disparate treatment claim. This is anybody in our community saying, I believe that something bad happened to me at work or at school. And I believe that that's something bad that happened because I'm a member of a particular protected class, right? I'm a member of this racial group. I'm a member of this, gender category, et cetera, all the different categories that are listed in our policy. The types of things that we see coming up are disparity in pay for similarly situated faculty on the basis of their gender. For example, we might get that kind of claim. We might get refusal to provide a job benefit provided to colleagues of a different protected class, right? For example, only providing mentoring, training, or funding to attend conferences to employees of a particular race or ethnicity. So these are the kinds of things that we see. And this starts a process where the person, kind of makes out the claim and meets a certain threshold to say that they've been discriminated against. And then we will talk to the person who's accused of engaging in that behavior. And that person has an opportunity to articulate the reasons for the decision, if the reasons they believe are not discriminatory. And that starts this burden shifting process of people, saying, hey, that reason that's offered is pretext and the real reason was discrimination. And here's the evidence that I have to support that. And the types of things that we look at in looking at a disparate treatment claim are patterns of decision-making of a particular decision maker. We look at comments that may be made either verbally or in writing, other things that kind of, serve as a window into the motivations for the decision that are made. These are really difficult cases. They're hard, to prove. But when there is a pattern of decision-making, for example, that's pretty strong a pretty strong indicator of positive decisions for one group of people and negative decisions for another group of similarly situated people from a different group. That can be persuasive and important information in making that determination. But disparate treatment claims are the most basic kind of claim that we get. The second kind is not as common. This is where an adverse impact claim, and this is where an employer has a policy that appears to be neutral on its face, but the way it gets applied, it has a disparate impact on a particular group. So I'll give an example. Over 3 decades ago, the New York City, fire department had a requirement that all firefighters had to be 5'7" or taller to be firefighters. And 3 cultural groups got together in New York City and brought a class action lawsuit against the fire department, saying that including a minimum height requirement here of 5'7", screened them out at a rate that was higher than the rest of the population. Fire department was forced into a corner to either prove that being 5'7" or taller was critical to being a New York City firefighter, or they needed to prove that it was job related and consistent with business necessity, and they essentially could not prove either thing. And ultimately, the fire department lost that case and was not able to show that the 5'7" requirement was necessary, and they had to overturn the requirement. Other ways that adverse impact can play out: if a faculty member, for example, held an exam on a Saturday and offered no makeup for that exam, you could see how that would appear to be neutral on its face, would appear to apply to everybody in the same way, but could have a disparate impact on Sabbath observers. So adverse impact, not as common a claim that we get. They're usually filed against employers on broad sort of cases of systemic discrimination, but this is one of the types of things that we could see. Failure to accommodate claims springs from our responsibility under the ADA and under Title IX to provide accommodations in 3 areas: for religious observance issues. So to the extent that someone comes to the institution and asks for some kind of accommodation related to religion, we are required to come to the table in good faith to determine whether or not we can provide that accommodation. It doesn't mean that we have to provide whatever someone is asking for, even if it's not reasonable, but it does mean that we must come to the table and assess that case, each one individually, and we have to be able to document the analysis that we went through to make a determination about whether or not we could accommodate. The regulatory structure around religious accommodation is nowhere near as extensive or specific as the regulatory scheme for disability accommodations, but in all contexts, we are required to go through that good faith process. And the same is true for pregnancy and childbirth under Title IX. There are, a whole host of accommodations that we are required to consider and to provide for individuals who are dealing with pregnancy and childbirth. Okay. Any questions about failure to accommodate claim? Okay. I want to talk just really quickly about disability support services on our campus. I talked about it for a second earlier. So this is the central office. Right now, as I sit here talking to you, we have 3,867 students with disabilities now registered. And this includes undergraduate, graduate, professional school, and online students. The registration and eligibility determination process is rigorous and individualized. It's really important for our faculty to insist that students go through the DSS process for accommodations. You should not be engaging in conversations with students about their individual medical conditions or their need for accommodation. You should express that you care for them, and you should say you're committed to providing the accommodations that are required, but direct them to the Office for Disability Support Services. The letters that you might get as a faculty member that tell you what accommodations have been approved are really specific and give information about how the accommodations are to be applied. Students are expected to provide reasonable notice of their need for an accommodation. That doesn't mean that we won't sometimes get one, 3/4 of the way into the semester, but when it comes, that we're required to assess that request and provide a reasonable accommodation if it's warranted. Accommodations are not retroactive, so students can't come after something has occurred in terms of a grade and ask retroactively for an accommodation to be applied. They're prospective. It applies from the moment that the accommodation request is made. Accommodations are not arbitrary. Each accommodation is tied to a specific aspect of that student's disability and related limitation. Confidentiality with students with disability is really, really important. So all disability related information is considered part of a student's education record and is covered by FERPA. This is the federal privacy law that applies to students. And this includes electronic, paper, and any other types of written communication. You should never talk, to a student in front of others about an accommodation issue, even if they approach you in public. You should say, I'm happy to talk with you about that, but we need to find, one-on-one space to have that conversation. Any questions or concerns about disability accommodations, you should absolutely reach out to the disability office, and I would discourage, talking directly with students about concerns or problems that you have with an accommodation. So quickly, Title VII, sexual and non-sexual harassment. So from our case law, unwelcome conduct, harassment is defined in our case law, and it's defined as unwelcome conduct that's based on any protected class status that is severe or pervasive and that creates an offensive or hostile work environment. Now, why did the court include this severe or pervasive standard in the definition? They include it to limit the extent to which you get the one-time comment on one day being presented as an actionable claim of harassment. When the drafters were thinking about the type of conduct or the type of offender that they wanted to target, they were not thinking about the trite, inconsequential comment that doesn't alter somebody's work life. They're talking about something that is either so severe in the one instance or so pervasive that it actually alters the work or the academic, space. Now, this is the analytical framework that an office like mine would use, another office would use to assess a claim. But I cannot say strongly enough that we don't have to wait as an institution for something to reach a severe or pervasive level to intervene and get that conduct to stop, right? So this is important because, we have to know that this is the legal standard, but we can intervene well before that happens. And usually it is easier to solve something at an early stage, well before it gets to the severe pervasive level. Here, I want to talk a little bit about the types of communications that end up, showing themselves in our investigations of various kinds of discrimination and harassment claims. So when I first started doing this work many years ago, social media and electronic communications were not part of the picture, and now they're part of every picture. Every Title IX sexual harassment case investigative report that we issue has attachments like A through O, and most of the things that are in those attachments are communications between the parties on various platforms. All the ones you see here, many others. So really important to understand that the concept of the American work environment is a fluid concept. It's anywhere that you go that has an impact on that person's work or academic life. So you should really think about all of the policies and the rules that I'm talking about here apply online, in study abroad, in clinical sites, wherever we go, our students are subject to these protections and to these rules. So examples of non-sexual harassment, the types of things we see coming into our various offices: somebody making fun of a person's disability or health condition, gossiping or saying disparaging things about a person's religious practices, use of race-based derogatory terms. And sometimes we hear people saying, well, it was, either used in passing or the comments weren't being directed at the person who's complaining. And none of that matters for the purposes of assessing a harassment claim. If these things are happening, being said in the work environment, and they're an earshot of others, they're fair game for somebody to raise a concern about harassment and hostile environment, academic or workplace hostile environment. Intent versus impact. I try to make sure that everybody kind of gets this message, that often what I hear when somebody complains, I hear from a supervisor or a person who's, familiar with the person who's accused. They say to me, well, they don't have a bad bone in their body and they didn't mean to cause harm. There was no malevolent intent here. And the belief is that if there's no intent, then there can be no harassment finding. And I just can't say strongly enough, the intent of the alleged harasser does not control. The relevant consideration is the impact on the recipient of that behavior. And that's what's going to determine whether or not a court, an administrative agency, the Department of Education would characterize our environments as hostile. It's about the impact. So we care about intent. It's important for us to understand that as part of the work that we do, but it's not going to control. So really important for leaders and faculty that are leading our groups of students to understand that, we need to, inculcate a sense of urgency around people being aware of how their words and their conduct are impacting the people around us. So really important to, to model that and to insist that other people, make themselves aware of how their conduct is impacting others. And if they see that something negative has happened, to address it in real time and self-correct, okay? The complaint pathways for non-Title IX discrimination. I want to make sure that in the equal opportunity policy that I talked about, all these complaint pathways are spelled out. But for non-sexual discrimination complaints about a faculty member's conduct, you go to the Faculty Affairs Office. That's the office that's responsible for dealing with those kinds of complaints. For non-sexual discrimination complaints about staff conduct, you'd be going to the Equal Opportunity Office in Human Resources, and the link is there for the contact for that office. And for non-sexual discrimination complaints about student conduct, you'd contact the Student Rights and Responsibilities Office, because they administer the review process for discrimination complaints against students. Any questions about these pathways? So as you can see, it's really about who the respondent is, who is the accused person, because it's the office that has jurisdiction over that accused person that would lead that investigation. Any questions about that? Okay. So bias incident reporting, and I want to make sure that I distinguish the bias incident reporting process from both the Title IX process for sexual misconduct and from the non-sexual discrimination, complaint pathways that I just talked about. So bias incident reporting is just for students, right? This is about incidents that involve our students. It is a mechanism for reporting students' concerns that's managed by my office. It's non-disciplinary, so no sanction can come from the bias incident reporting process. It's really about responding to students in real time when something has occurred and they're very impacted. Sometimes the length of these other processes that I talked about are really not responsive to a student that's in crisis and needs some support in the moment, right? So we respond within 24 to 48 hours to that student directly. We will meet with students, we will hear them out. We will make an assessment about whether or not they need to be referred to an office for some kind of support. If academic accommodations are needed, we might, reach out depending on what the circumstance is. We might do mediations with the person who's, on the receiving end of that bias incident report. We've had circumstances where faculty have been the recipients of, of reports or the target of a bias incident report. And oftentimes we get faculty who know that something bad happened. They sense that, something occurred that, impacted students in a negative way, but they were unclear about the pathway for addressing it. We will provide coaching and support for that faculty member if they're interested in that. Sometimes faculty are not, and that's fine, because our process is, again, not a sanctioning or disciplinary process, but we find that most people want support and help in trying to address a bias concern that gets raised. We will also do dialogue with a group that's been impacted, either a work group or an academic group. And, depending on what we hear in bias reports, we might make recommendations about initiatives or programs for a particular department or unit. So it really is going to be individualized and tailored to whatever the unique circumstances. And you'll see here, there's a bias incident response homepage link and also an online report form link, because you can file reports online. We do take anonymous reports. Obviously, if the reports are anonymous, the response is only as good as the information and the detail that we get, but we will make every effort to respond to a report that we receive. Any questions about bias incident reporting? Okay. So quickly, Title IX harassment, we talked about this earlier, covers, sexual discrimination in higher education settings, and it includes sexual violence which is defined as a form of sex discrimination specifically prohibited by Title IX. It covers the entire environment. It's very, very broad in its scope. So it covers students, faculty, staff, volunteers, and other individuals that are participating in university programs or activities. So even a person that is not a member, not a GW affiliate, who has some kind of interaction with a member of our community, if they're raising a concern about behavior, we sometimes have gotten Title IX reports from an American university student, for example, that has an interaction with a GW student. And if that student, files a report with the Title IX office, then we are duty bound under our policy to move forward with that investigation. It covers any sex discrimination, and that includes sexual harassment, sexual assault, dating or domestic violence, and stalking. And it requires specifically that we provide supportive measures to parties while we are conducting a review. Where does this does the Title IX policy apply? It applies within a university program or activity, whether on or off campus, within any building owned or controlled by a recognized student organization like a fraternity, sorority house. It also applies outside the university's programs or activities where appropriate. So that would include study abroad. That would include, gatherings, social gatherings outside of work. All of that would be fair game. And the idea behind Title IX is that if we allow people to be subjected to the kinds of conduct that are specifically prohibited, it denies, those individuals equal access to educational opportunities. Okay, so that's the scope. Our responsibility broadly under Title IX is to promptly respond, to eliminate the sexual harassment, to provide supportive measures, to prevent its reoccurrence, and to address its effects. So it's a really broad responsibility to abate whatever harassment we learn about, but then also to prevent it from happening again in a reasonable manner. I'm not going to go through each of these, but these are the definitions of sexual harassment and other, forms of sex discrimination covered by our policy. And so you'll see here the specific definitions. All of these are prohibited by the policy. Examples of sexual harassment, hostile environment issues that we see: discussing one's sexual activities at work or joking about sexual preferences of coworkers, supervisor asking an employee out for drinks or dinner, and when rejected, the supervisor threatens to fire the employee. That is the most serious form of sexual harassment, and from a liability standpoint for an institution, in every place where I have worked, when all of the elements there are shown, somebody who's above another in the chain of command propositions somebody that's below them in the chain of command, threatens or actually carries out a threat to harm them if they reject that advance. When all four of those things are shown, there's almost always a termination, because that is direct liability. As faculty working with GW, you are considered an extension of GW, and your actions are binding on GW. So really, really important for you to avoid this behavior, and for you to stop that behavior if you see it. So discussing the attractiveness or body features of colleagues within the office. So really any comments about body, clothing, appearance, I would avoid those. I'm not saying that it's illegal to tell somebody they look nice today, but the kinds of comments that come in to us are not that kind of comment. It's typically very specific comments focused on people's parts of people's bodies or features. Never a good idea, and we want to root that out when we see it happening. Having an inappropriate ringtone that can be heard by other staff members, having inappropriate content on your screen that others can see or be offended by. And it can occur in educational or employment settings, including online formats and group chats. Okay. Any questions about any of this? Okay. And I see this sometimes coming up in labs. So a lab will have a group chat, and the group chat starts to get really inappropriate, and there might be a supervisor on that group chat, or a leader, a faculty member, a PI is on the group chat, and there's this inappropriate stuff happening. So even in that context, that seems sort of innocuous, these are the kinds of things that end up being being evidence in a hostile work or academic environment case. So we really have to be mindful when we see those things crop up. So when and how does sexual harassment occur? The target of the harassment, as well as the harasser, may be male or female. Parties may be of the same sex. The complainant does not have to be the person harassed, but could be anyone affected by the offensive conduct, right? So again, we want to make sure that, that we're addressing anything that we see coming up in the work environment. And sometimes I include this slide still, because I still get some people saying, well, it's not harassment because it was a female respondent and the person complaining is male. I mean, I've actually, heard that in the last couple of years. So it's just really, really important for us to understand that that is not how the policy operates, it's not how the law operates. If the conduct that, that's been prohibited occurs, we have to address it. Everybody on this call is a designated reporter under our Title IX policy. If you learn about something that could be a violation of the policy, any one of those, prohibited behaviors that I talked about earlier, you should just pick up the phone and, I'm going to give you a number of mechanisms to do that, but just get the information to the Title IX office. You don't have to sort it out. You don't have to assess whether or not there's merit to it. Just report it and let the university do outreach to that potentially impacted person. They can totally ignore us. They don't have to go forward with any kind of process with the Title IX office, but you have discharged your obligation to notify the Title IX office that you heard about this. Okay. And everybody on this call is a designated reporter under our policy. You'll have these slides. I encourage you to use the QR code here. You can download information to your phone directly about the contact information for the Title IX office. You can file a report in a number of ways here, online form, you can call, you can email. We have a 24-hour line that's staffed by the Title IX office. You could do a care report, which is out of student affairs. They'll get a report to us, but either use one of these mechanisms to get a report to the Title IX office. You can also report to the police department. I note that we are not required, if the person is not a minor, there's no obligation for the university to report to the police. And in fact, the regulations say we want that power to remain with the person impacted to decide if they want to engage the police, right? So if the student is not a minor, and you hear about something involving, sexual misconduct, really anybody in the community, you hear about sexual misconduct, you can call GWPD if you think that what's happening is an immediate threat of, physical harm or safety for that person or someone else. But really what you should do is just contact the Title IX office. If a security issue is not on the table, contact the Title IX office in any one of the ways that are listed there. You can also speak to a confidential resource or encourage a student to speak to a confidential resource. We have a counseling and psychological services office. The number is there. And we have an office of advocacy and support, and the contact information is there. I won't go through this, but this is the, when you look, if you have time and you're interested, this is what happens when somebody files a report with the Title IX office. So that it lays out, a series of steps, either from an outreach email that goes out, offering services and support to a student, to an intake meeting, supportive measures, an actual decision point where somebody decides to file a complaint, and then either an alternative resolution if both parties agree, or a formal resolution process that includes a hearing and a possibility of an appeal, okay? And so there's all the information about that process is there. There's more information on this slide about supportive measures that are available and all the different things that we will do. We do an individualized case assessment for any student that comes through. And these are all the types of, on the slide here, you'll see all the different types of things that we might do for a student. And we often will get a request that's maybe not on that slide, but that is a unique circumstance for that particular student. As a faculty member, you could hear from the Title IX office from time to time asking you to make some kind of academic accommodation. If we are presented with a student that's dealing with trauma or medical issues connected to a sexual assault, we will ask for, your support in trying to accommodate the unique needs of that student. And I encourage you to work with the Title IX office. This is a slide that has all the things that we are required to do for students who are pregnant. And I imagine that for graduate students, this is more of an issue potentially. And essentially what Title IX regs say here is that we have to restore, if a student is impacted by pregnancy in any way, we have to restore that student to the position that they would be in if the pregnancy related complication had not occurred, right? And so we've got to make sure that we are adhering to the requirements that are here. This outlines the alternative resolution process and what could come from it. It really is case specific and very individualized for the folks that are in that process. Different people want different things. And so it really is up to the two parties to agree to a resolution and for the Title IX office to agree to that resolution. If somebody decides to go through a formal process, it could result in a hearing, and the result is either a finding of responsible or not responsible, and then ultimately a disciplinary authority at the university would make a decision, and then both parties have the right to appeal. They have to file within 5 days of the decision and the sanction. Imagine when somebody comes to you to report a sexual assault, I mean, imagine it usually takes a lot of courage for somebody to do that. And if they do, imagine the second you get that report, that is the beginning of the narrative of how GW responded, right? So what you do, what you say, your body language, all of that is going to be really important. You want to listen and thank them for telling you, and listen without judgment. You want to pause if necessary and explain your status as a designated reporter. Don't let them get way down into the story without understanding that you have an obligation to report what you hear to the Title IX office. You want to be supportive and be empathetic and compassionate and try to set some healthy boundaries. You want to assist and ask how you can best support them. Ask what they need, from you. If they're coming to you, it's usually because they have an immediate need. You want to offer resources, but respect their wishes on how they want to proceed. And you want to let them know that they will likely hear from the Title IX office, and that they can choose not to respond if that's what they decide to do. But it's really important for you to discharge your obligation to send that information to the Title IX office. And then if you can, you want to try to make sure that you connect them directly. All of our anti-discrimination laws have anti-retaliation provisions that essentially say that people who file complaints, people who participate in investigation, or simply oppose discrimination, all of this is considered protected activity. If we seek to harm somebody because they complained, that is a separate cause of action and a separate violation of our policy. So we could actually do a whole full investigation and find no discrimination on the part of a faculty member, but that same faculty member could get found guilty of violating the university's retaliation policy if they acted out against that student because they complained. So really, really important to respect people's right to use the process. Even if we disagree with them, you'll get an opportunity to give your side of what occurred. Don't act out against anybody that seeks to use the protection of our policies. I have a couple of slides in here which you should take a look at if you're interested about the different ways that people raise retaliation concerns, particularly in an academic space and an academic context. Possible actions or remedies that could come from Title IX cases in particular. It could be as low level as a warning, either verbal or in writing, and it could be as serious as expulsion or termination. So the stakes here are very high with Title IX cases. Our cases are heard by external retired judges. Those are the people that are making the determinations about responsibility. And ultimately, the disciplinary authority within the university would make a decision about sanction, and the sanctions can be very serious with the kinds of violations. I think civility is the best anti-discrimination tool that we have. I won't get on a soapbox about that. Landmines for leaders. I would encourage you to just take a look at this. Blurry boundaries with students almost always, end badly for our faculty. Favoritism based on gender comes up a lot. We hear about that a lot. Any disparaging comments made about gender, age, race, ethnicity can destroy trust in a classroom, can, in a research setting, in a clinical environment, and can be linked to a failing grade or some kind of unfavorable decision. So we shouldn't make disparaging comments on any of these bases because it's the right thing to do. But in addition to that, it opens you up to somebody linking a disparaging comment that you make about a group of people to an unfavorable decision that you might make, right? So really important to avoid that. There's some slides here on the policy on prohibited relationships, but I really gave you the bottom line and the most important pieces there. No relationships with undergraduates, no relationships with graduate students that you teach or supervise, right? And then the minors policy, just report, report, report. This is just the last couple of slides are just resources. This is contact information for the people who had all the offices that I mentioned. Did I make it? Okay, I'm a little over, I'm sorry. But that's the end of the presentation. I'm going to stop sharing here. I'm happy to take any questions if you have them.
I'd like to add one additional feature. Thank you so much, Caroline. This is really very helpful. Mm-hmm. Most of our investigators are funded by the National Institutes of Health, and I want to make our investigators aware that last month, the NIH released a report that requires institutions that find that individuals who are PIs or key personnel who have been found to be disciplined due to concerns about harassment, bullying, or hostile working conditions have to be reported to the NIH. That's a really interesting issue. The second part I didn't know when I read that policy is that the NIH has confidential reporting form that anybody in the community can report such a thing directly to the NIH. So I think our investigators need to be aware that our funding agencies, our universities are taking these issues very seriously.